100% American made. And darn proud of it. The Charlie Kirk Show.
All right. Welcome back to the Charlie Kirk Show. Andrew Kolvet in here after an amazing weekend. And I actually got to see the good folks at WhyRefi. Amazing people. Just salt of the earth, solid as a rock, and just have our back, have the country's back. And just honored to be in the trenches with them. And what they do is they help you refinance distressed or defaulted private student loans that other people won't touch. So private student loan debt in the United States totals about $300 billion, and about $45 billion of that is labeled as distress. And if that is you, they can help you get out from under your distressed or defaulted private student loans. WhyRefi can reduce your monthly payment and guarantees interest rates under 6%, ensuring affordability and financial relief. They do not care what your credit score is. So you got to check them out. You can even skip a payment every 6 months up to 12 times without penalty. You do not have to ignore that mountain of student loan statements on your kitchen table anymore. Just call 888-WhyRefi34. That's 888-WhyRefi34, or log on to WhyRefi.com, YREFY.com, YREFY.com. May not be available in all 50 states. We will be right back with radio. All right, welcome back to the Charlie Kirk Show, radio stations across the country. Blake, here's what we're going to get into. We're gonna explain this birthright citizenship, the dynamics of it, because I think it's really important. There are, in 2023, which is the last year that I have data on, there were between 225,000 and 250,000 babies born to illegal immigrants. They believe that this could impact up to 4.3 million retroactively births, because remember, Trump did this, and the way they're going to work it out and the way they're going to move forward is TBD, but it could impact up to 4.3 million children. So it's a huge deal. But and when we're talking about historical significance and moving forward, that number obviously is going to be even larger. So the language in the 14th Amendment was derived from the 1866 Civil Rights Act. So this is, again, right after the Civil War. The intent was to give citizenship to freed slaves and the children of freed slaves. And the language in that 1866 Civil Rights Act, from which this was derived, said all persons born in the United States and not subject to any foreign power would be considered citizens. Now, this also gets lost in the shuffle. Two Supreme Court cases upheld that the 14th Amendment excluded citizens of foreign countries born in the U.S., the Slaughterhouse cases in 1872 and Elk v. Wilkins in 1884. Now, birthright proponents like to cite the 1898 Supreme Court case, which was United States versus Kim, but they conveniently forget that that case was about the child of a Chinese parents that resided in the United States permanently and lawfully. So the big idea here is that the 14th Amendment was intended to grant citizenship to freed slaves born in America and their children, not to illegals who owe allegiance and are citizens of a foreign country. And here's the key quote, Blake. This is the one that everybody's going to be talking about and arguing around in this Supreme Court oral argument. Subject to the jurisdiction thereof. And one last point, Blake, before I throw it to you. There is a reason that American Indians did not receive citizenship until 1924 with the passage of the Indian Citizenship Act. Now, you have to ask yourself, why? Why did they not receive citizenship? They were born on American soil, presumably, but this is the key. They were considered to owe allegiance to native sovereignty, to their own tribal nations. And they were not automatically considered to owe allegiance to the United States. And therefore, it took an extra step passed by Congress in 1924, the Indian Citizenship Act. So if everybody simply born on American soil is automatically a citizen, you have to ask yourself, why not the Native Americans? That's the question I would like anybody that is a proponent of birthright citizenship for illegals or tourists or whatever to answer me. Blake, over to you. I know you got thoughts.
So that Wong Kim Ark decision from the late 1800s, that's very important because it gets at one of the biggest lies they'll say is that this is settled law. The Supreme Court of the United States has only ever ruled on whether birthright citizenship extends to the children of those legally in the United States.
And permanently.
That's all they ever ruled on, legally and permanently, which his parents were. And they've never ruled on illegal immigrants. They've never ruled on birth tourism. And that is just sort of something that liberals in the U.S. federal government just asserted, lower level courts asserted it, and we let them get away with it until it grew into this huge tumor that is consuming the United States. As you said, hundreds of thousands of births a year to illegal immigrants. There are millions of people who have citizenship as a result of that. Among other things, it causes illegal immigrants to receive a huge amount of welfare benefits because even if you're an illegal, if your anchor baby is a U.S. citizen, you become eligible for food stamps and a whole bunch of other things. And it's all based on this myth. It's based on a myth that it somehow just obviously means anyone born in the U.S. qualifies. No, that line, subject to the jurisdiction thereof. It means essentially owing allegiance, owing fealty to that nation. It actually, if you dig deep into the roots of it, it derives from legal ideas of like owing loyalty to the king. Could you commit treason against the king? If you are not able to commit treason against the United States, then I don't think it makes sense to say that you're subject to the jurisdiction of the United States.
Well,
and I'm hopeful the Supreme Court will rule that way. My biggest fear is they'll try some pragmatic decision where they would just say, oh, well, it would be too disruptive to change the law. I think the actual meaning of the law is extremely clear that this level of birthright citizenship we've had for so many years is not tenable or defensible.
The original drafter of this clause, Senator Jacob M. Howard of Michigan, said in the arguments, this will not, of course, include persons born in the United States who are foreigners, aliens, or belong to families of ambassadors or foreign ministers. Oh, man. Jack Posobiec joins us next.